Good day, everyone. Our topic for today is the general provisions on obligations. Last week, diniscuss natin yung introduction to law and I hope we were enlightened kung ano ba ang overview natin, kung ano ang concepts natin pagdating sa law, and this time, pupunta na tayo sa mas specific, which is ito na ngang obligations. By the way, ang ating subject matter, law on obligations and contracts, ay divided into two main subtopics. First is obligations and second part is contracts. So for now, papasok na tayo sa general provisions on obligations. This module has three subtopics. First, definition of obligation. Second, essential requisites of an obligation. Third, sources of obligations. At the end of the module or this presentation, the students should be able to first discuss the essential requisites or elements of an obligation. Second, compare and contrast the 5 sources of obligations under the provisions of the new civil code. And third, determine the form or manner by which an obligation shall be incurred or manifested to be binding and enforceable to both contracting parties. So, ayon, our topic, obligations, is found under Title 1 of the new civil code, under Articles 1156 to 1304. So, for now, we will discuss Chapter 1, General Provisions. So, ang first provision under obligations is Article 1156. This article, you should memorize by heart kasi ito yung magiging foundation ng ating mga subsequent discussions pagdating sa obligations and contracts. Nakalagay dito, an obligation is a juridical necessity to give, to do, or not to do. This article describes the definition of obligation. Itong article na ito bali ang definition ng obligation. And the term obligation is derived from the Latin word obligatio, which means tying or binding. Sa Tagalog, nagtatali. Let us first take note of the nature of obligations under the Civil Code. And later on, we will identify whether this obligation na pinapatungkulan nitong Article 1156 ay alin sa dalawang ito. So first, we discuss about civil obligations. Civil obligations are those which give to the creditor or obligee a right under the law to enforce their performance in courts of justice. Sa madaling sabi, yung civil obligations, pwede siyang i-enforce in courts of justice. Sa kabilang banda, yung natural obligations, they are not based on positive law, but on equity and natural law. They do not grant a right of action to enforce their performance, although in case of voluntary fulfillment by the debtor, the latter may not recover what has been delivered or rendered by reason thereof. So, to which kind of obligation does Article 1156 refer to? The answer is civil obligation. Bakit? Kasi it has a binding force in law and which gives to the obligee or creditor the right of enforcing it against the obligor or debtor in a court of justice. Natural obligation, on the other hand, is one which cannot be enforced by action, but which is binding on the party who makes it in conscience and according to the natural law. So, between these two, civil obligation lang po yung pwede nating i-enforce. Pwedeng i-enforce ng courts. Kung babalikan natin yung definition, nakalagay dito, juridical necessity. Kaya siya sinabing juridical necessity, enforceable siya sa ating courts. So, another description ng ating definition ng obligation, it is provided herein that Article 1156 of the Civil Code defines an obligation in its passive aspect. It merely stresses the duty of the debtor or obligor when it speaks of obligation as a juridical necessity. So, itong passive aspect na to, mas maiintindihan natin to later on. Kasi, pag sinabi nating passive aspect, ito yung duty ng debtor or obligor, yung party na bound to perform an obligation, yun ay tinatawag natin na passive aspect. In contrast with the active aspect, which is the duty on the part of the creditor naman to demand fulfillment. Later on, mas maintindihan natin kapag na-discuss na din natin yung elements of an obligation. So, let us just take note dito sa definition na to na Article 1156 defines an obligation in its passive aspect. So again, with juridical necessity, we mean that obligation is a juridical necessity because in case of non-compliance, the courts of justice may be called upon by the aggrieved party to enforce its fulfillment or in default thereof the economic value that it represents. Yun nga, in case of non-compliance ng ating, halimbawa ng ating other party sa contract, pwede tayong mag-resort sa courts of justice. Kasi nga civil obligation yung pinag-uusapan natin dito. In proper cases, the debtor or obligor may also be made liable for damages, sa Tagalog ay danyos, which represents the sum of money given as a compensation for the injury, kabayaran daw for the injury or harm suffered by the creditor for the violation of his rights. In other words, the debtor must comply with his obligation whether he likes it or not. Otherwise, his failure will cause harmful or undesirable consequences. If obligations were not made enforceable, then people can disregard them with impunity. Matatandaan natin from our previous discussion that we characterized law as obligatory. Ito na yung isang manifestation na law is obligatory. We must comply with our obligation whether we like it or not. And we have to remember na itong Article 1156 is one law under our legal system. So, kasama siya sa characterized as obligatory. Pasok na tayo sa essential requisites of an obligation para mas maintindihan nyo yung mga binabanggit natin kanina, mga debtor obligor, creditor obligee. So, pag sinabi natin passive subject, bali meron pala tayong 4 na essential requisites of an obligation. First is passive subject or the debtor or obligor. Second, active subject, creditor or obligee. Third, object or prestation, subject matter of the obligation. And fourth, juridical or legal tie or the efficient cause or source of the obligation. So, pag sinabi nating passive subject, we refer to the person who is bound to the fulfillment of the obligation. He who has a duty. Pag sinabi nating passive subject, ito yung person na according to the agreement, siya yung bound to fulfill the obligation. Siya yung may duty to perform the obligation. That is the person na tinatawag natin na obligor or debtor. Yun namang sinasabi nating active subject, yung creditor or obligee, it is the person who is entitled to demand. Kaya siya, the person who is entitled to demand the fulfillment of the obligation, he who has a right. Kaya siya naging active subject kasi he is entitled to demand the fulfillment. Yun yung pinaka-active duty niya. So, ang active subject natin, creditor or obligee, siya yung nagda-demand ng fulfillment of the obligation. So, next essential requisite is object or prestation, or otherwise known as the subject matter of the obligation. Ano ito? It is the conduct required to be observed by the debtor or obligor. It may consist in giving, doing, or not doing. Without the prestation, there is nothing to perform. So, ayon, ang object or prestation is yung subject matter ng obligation. Yung object or prestation, pwede siyang duty to give, to do or not to do, as provided sa ating Article 1156. And lastly, juridical or legal tie, efficient cause or source of the obligation, that which binds or connects the parties to the obligation. So, for us to understand better, we have an example here. Under a building contract, Vice bound himself to construct the house of Pastor for 1 million. Bale, ito yung ating contract or agreement. So, dito, ang passive subject or obligor, one who has the duty to perform is Vice. Active subject or obligee, or otherwise known as creditor, is Pastor. Bakit? Kasi siya yung may right to demand the fulfillment of the obligation. Siya yung magdademand kay Vice, who bound himself to construct the house. And object or prestation, ano ba ang subject matter? Construction of the house. The construction of the house of Pastor. And lastly, juridical or legal tie, ano ba yung source ng obligation? The building contract. Building contract itself na in-enter ni Vice and Pastor. So, ayun, passive subject or obligor, again, is Vice. Siya yung may duty. Active subject or obligee, si Pastor. Siya yung may right to demand the fulfillment of the obligation. Object or prestation, construction of the house, and juridical or legal tie or your source of obligation is the building contract. So, next scenario naman tayo. Suppose Vice was the obligor kanina. One who has the duty kanina, had already constructed the house, and it was the agreement that Pastor would pay Vice after the construction is finished. So, this time, bali kanina pala, Pastor was the obligee, yung may right to demand the fulfillment of the obligation. Ngayon, since tapos na yung previous agreement, executed na siya, pupunta na tayo sa payment. And pagdating sa payment, ang may duty na ngayon to pay is pastor. So, pastor now becomes the passive subject, while vice becomes the active subject. Pastor now becomes the obligor kasi siya na yung may duty to pay, and vice becomes the obligee now because siya na yung may right to demand the fulfillment of the obligation, which is to pay the amount of 1 million. So, ayun. I hope na clear tayo sa essential requisites. So, we will now go to form of obligations. The form of an obligation refers to the manner in which an obligation is manifested or incurred. It may be oral, in writing, or partly oral and partly in writing. Pwede daw verbal or oral, pwedeng documented or in writing, or pwede ding mixed, partly oral and partly in writing. It is sometimes referred to as the fifth requisite. May mga authors na nagsasabi na ito ay fifth requisite, di ba? 4 yung kanina na requisites. Passive subject, active subject, object or prestation, juridical or legal tie. May ibang authors na nagsasabi na fifth requisite daw is form. However, hindi natin siya pwedeng pagrelayan considering that hindi siya considered essential kasi as a general rule, the law does not require an obligation to be in any form. Clear tayo na in any form for its validity or binding force. So, yon as a general rule, walang required na form. Kasi nga, sabi nga natin kanina, pwede siyang oral, pwede siyang writing, or partly oral and partly in writing, and they are all valid. Meron lang tayong ilang exceptions pagdating dito sa rule, sa general rule natin na ito. Halimbawa, dito sa mga obligations na to, merong specific form na kailangang masunod in order for such contract to be valid. Example, contract involving donation of personal property whose value exceeds 5,000, the law requires that the donation and the acceptance shall be made in writing. Dapat daw nakasulat yung donation and acceptance. Next, contract of sale of a piece of land or any interest therein. Yung sa ating mga real estate or any interest therein through an agent. The law requires that the authority of the agent of the latter shall be in writing. Yung daw authority ng agent to sell such piece of land or any interest therein shall be in writing. So, ito yung mga specific requirements sa form na exception sa general rule. Contract of simple loan or mutuum, the law requires that the amount of the principal and of the interest shall be specified in writing. And marami pa pong iba na i-discuss natin in detail sa mga susunod nating discussion pagdating sa forms. Pero we have to remember na as a general rule, the law does not require an obligation to be in any form for its validity or binding force. So, we proceed now with the distinction between obligation, right, and wrong. Pag sinabi nating obligation, it is the act or performance which the law will enforce. Right is the power which a person has under the law to demand from another any prestation. And lastly, a wrong or cause of action is an act or omission of one party in violation of the legal rights of another. So, the following are the essential elements of a legal wrong or injury. First, a legal right in favor of a person, and that person pertains to the creditor or plaintiff. Second, a correlative legal obligation on the part of another, yung person na yun ay debtor or defendant, not to respect or not to violate said right. And third, an act or omission by the latter in violation of said right with resulting injury or damage to the former. So, sabi po dito, for a legal wrong or injury to exist, una, dapat merong legal right in favor of a person. Halimbawa, si A, may legal right siya. And then, second element, a correlative legal obligation on the part of another not to respect or not to violate said right. So, halimbawa si B, meron naman siyang legal obligation para i-respect or wag i-violate yung right ni A. So, sa third element, pasok tayo sa third element, an act or omission by the latter in violation of said right with resulting injury or damage to the former. So, pag itong si B, nag-commit siya ng act or omission, pag sinabi nating act or omission, act is positive, while omission is negative. Omission is yung wala kang ginawa. Pag may kinomit si B na act or omission in violation of said right of A, na nag-result sa injury or damage kay A, then we can already say that there is already a legal wrong or injury. These essential elements dapat complete for us to say na merong legal wrong or injury. So, now we proceed with the kinds of obligation according to the subject matter. Marami tayong classifications ng obligation, pero first, we go to that according to subject matter. First is real obligation and second is personal obligation. Kapag sinabi nating real obligation, it is the obligation to give. That in which a subject matter is a thing. Syempre, pag ang obligation natin ay magbigay, so ang ating subject matter ay isang thing, which the obligor must deliver to the obligee. Example, seller binds himself to deliver a box of face mask to buyer. So, siya ay real obligation kasi ang ating obligation dito is to give or to deliver a box of face mask. Ang subject matter natin ay box of face mask. On the other hand, personal obligation naman, obligation to do or not to do. That in which the subject matter is an act to be done or not to be done. So, pag sinabi nating positive, personal obligation, ito yung obligation to do or to render service. Pag sinabi naman nating negative, obligation not to do. Again, kung babalikan natin ng Article 1156, an obligation is a juridical necessity to give. So, yun yung real obligation. To do or not to do. Yun yung personal obligation. So, pag sinabi nating to do or render service, yun ay positive personal obligation. And when we say obligation not to do, ito naman yung negative personal obligation. Example natin sa positive personal obligation is, as a student, your positive personal obligation is to study. Yun yung inyong to do. And Example naman ng negative, as a student, your negative personal obligation is not to violate school policies. So, ayun. We proceed now with Article 1157. Nakalagay dito, obligations arise from law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. So, itong article na ito speaks about our sources of obligations. Huwag tayong malilito sa sources of obligations versus sources of law. We discussed nung previous discussion natin yung sources of law. We have primary and secondary. Hindi na yon yung tinutukoy natin ngayon dito sa sources of obligations. Pag sinabi natin sources of obligations, ito yung 5. Law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. So, ayan, huwag kayong malilito sa sources of obligations and sources of law. When we say that law is the source of an obligation, it means that the obligation is imposed by the law itself. Pag sinabi natin law, example, obligation to pay taxes, nakaprovide ito sa ating National Internal Revenue Code, which is a law. Next is obligation to support one's family. Nakasaad din po ito sa ating Civil Code, which is also a law. So, whenever specifically provided by the law, we can say that the source of such obligation is law. Next one is contracts. Pag sinabi naman po natin contracts and source ng obligation, it is when the obligation arises from the stipulation of the parties. Galing daw po sa pinagkasunduan ng parties. Example, the obligation to pay indebtedness by virtue of a contract or an agreement. Yung obligation daw po na magbayad ng pagkakautang by virtue of a contract or an agreement. Next is quasi-contracts. Pag sinabi po natin quasi-contracts, these obligations arise from lawful. You have to take note of these elements: lawful, voluntary, and unilateral acts, which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of another. So, as previously discussed, pagdating sa sinasabi nating quasi, yung term na quasi, pwede natin siyang, in layman's term, pwede natin sabihin semi, parang, ganon. So that we can better understand kung anong ibig sabihin ng quasi-contracts. Siya ay hindi exactly contract, pero there results a silent agreement between the parties, kaya siya tinawag na quasi-contracts. Kasi, pag sinabi natin contracts, specifically, nag-agree yung parties. Pero in this case, walang agreement, walang express agreement, so siya ay tinawag na quasi-contracts. Example, ay obligation to return money paid by mistake or that which is not due. Yung obligation daw po na ibalik natin yung pera na natanggap natin by mistake or that hindi naman due, yun po ay isang example ng quasi-contract. We will discuss more about this later on. Number 4, acts or omissions punishable by law, otherwise known as crimes or delicts. When the obligation arises from civil liability as a consequence of a criminal offense. So, yung obligation po dito, yung source ng obligation is the crime, and yung obligation arises from civil liability. Example, the obligation of the thief to return the things stolen by him, the duty of the offender to indemnify the heirs of the victim. May separate discussion din po tayo mamaya dito, pero let us first take note that crime or delicts, other term for crime, acts or omissions punishable by law, is a source of obligation. Next is quasi-delicts or torts. Another quasi-delict. Delict is a crime, so this is, pwede natin siyang i-describe as semi-crime. Parang ganun yung dating. It resembles a crime. Parang ganun. Pero ang term niya talaga is quasi-delicts or torts. This happens when the obligation arises from damage caused to another through an act or omission, there being fault or negligence. So, ito naman yung distinguishing element niya. May fault or negligence, but no contractual relation exists between the parties. Bale, meron daw pong damage caused to another through an act or omission. May ginawa or hindi ginawa. There being fault or negligence, ibig sabihin there was no intention to cause such damage to another. And that no contractual relation. Walang contractual relation yung parties before the commission of such act or omission. Example po nito para mas maintindihan natin is the obligation of the possessor of an animal to pay for the damage which it may have caused. So, halimbawa daw po yung animal na pag-aari ni A ay nakadamage ng property ni B. Wala silang previous contractual relation. Hindi rin naman sinadya na ipasira dun sa animal yung property ni B. So, masasabi natin na it was not intentional. There was only fault or negligence. Then, magkakaroon ngayon ng obligation si A to pay for the damage caused by the animal. So, yun yung source ng obligation under quasi-delict or torts. Article 1158. So, Article 1158 speaks about the characteristic of obligations derived from law. Sabi dito, obligations derived from law are not presumed. It means that only those expressly determined in this code. Pag sinabi po natin in this code, we refer to the civil code. Or in special laws are demandable. Yun lang daw pong expressly determined, expressly provided sa civil code or in special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this book. Ang tinutukoy din po ditong book ay Civil Code. So, ayun po, clear tayo na obligations derived from law are not presumed. Bakit daw po not presumed ang ating legal obligations? Precisely because they are considered a burden upon the obligor. They are the exception, not the rule. So, to be demandable, they must be clearly set forth. Dapat daw po clearly nakaprovide sa law. And when we say law, pagdating sa ating subject matter, we refer to the civil code or special laws. Article 1159, obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Pagdating naman po sa contractual obligations, contracts being the second source of obligations. Sabi po dito, yung obligations na nakaprovide sa contracts entered into by the parties, yun po yung magbabind sa parties as parang i-consider nilang batas. Yung kanyang legal authority, yung kanyang legal power between the contracting parties and should be complied with in good faith. So, the above article, 1159, speaks of contractual obligations or obligations arising from contracts or voluntary agreements. It presupposes that the contracts entered into are valid and enforceable. So, when we speak of contract, ibig sabihin po ng contract, it is a meeting of minds. Pagtatagpo ng mga isip, agreement between two persons whereby one binds himself with respect to the other to give something or to render some service. So, we have also to take note of this definition. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So, once meron na tayong contract, yun na po yung pinaka-law na mag-govern sa both parties. So, to discuss further, pag sinabi nating binding force, pag sinabi daw na yung contract ay magkakaroon ng binding force as law sa parties, ibig sabihin po nun, obligations arising from contracts have the force of law between the contracting parties. Parang as if i-consider siya na law between the contracting parties. They have the same binding effect of obligations imposed by law. However, this does not mean that contract is superior to the law. Hindi daw ibig sabihin yung contract ay superior to the law. As source of enforceable obligation, a contract must be valid and it cannot be valid if it is against the law. So, clear tayo na kahit na sinabi natin na obligations arising from contracts have the force of law between the contracting parties, we have to ensure first that the contract must be valid and not against the law. Kasi once na against the law yung nakalagay sa ating contracts, halimbawa yung contract na pinag-agrihan nyo, halimbawa is you are to deliver illegal drugs to B, to the person of B. That contract is not valid because it is against the law. So, hindi siya enforceable obligation and hindi natin mako-consider na yung obligation doon have the force of law between you and B. So, ayun. Pagdating naman sa validity of contracts, a contract is valid if all its essential requisites are present. Again, all po. All essential requisites are present, namely consent, object, cause, or consideration, and provided that it is not contrary to law, morals, good customs, public order, and public policy. Otherwise, it shall be declared void. Sinabi po nating void, null, without effect, invalid, and no obligation will arise. So, again, in making sure that a contract is valid, dapat nandoon ang lahat ng essential requisites niya. And when we say essential requisites of a contract, we refer to consent, object, or cause. Magkaiba ang essential requisites ng contract at essential requisites ng obligation. Huwag kayong malilito kasi pagdating sa contract, ang essential requisites niya ay consent, object, and cause. While sa ating essential requisites ng obligation, meron tayong passive subject, active subject, juridical tie, and object or prestation. So, pagdating sa contract, may limitation tayo na it cannot be contrary to law, it cannot be contrary to morals, to good customs, public order, and public policy for it to be valid. Third, compliance in good faith. Ibig sabihin ng compliance in good faith, kabaliktaran siya ng in bad faith. It means compliance or performance in accordance with the stipulations, in accordance daw sa pinag-agrihan or terms of the contract or agreement. That which is agreed upon in the contract is the law between the parties. So, clear tayo na, again, yung mga pinag-agrihan nyo sa kontrata, yun ang law between you and your and the other party. That which is agreed upon in the contract is the law between the parties thereto and must be complied with in good faith, provided that the agreement shall not be contrary to law, morals, good customs, public order, and public policy. Makikita po ulit natin dyan yung mga provisions na dapat not contrary to law, morals, good customs, public order, and public policy. Sincerity and honesty must be observed to prevent one party from taking undue advantage over the other. Non-compliance by a party with his legitimate obligations after receiving the benefits of a contract would constitute unjust enrichment on his part. So next, breach of contract. Kailan ba nagkakaroon ng tinatawag nating breach of contract? It takes place when a party fails or refuses to comply without legal reason or justification with his obligation under the contract as agreed upon. In most cases, it will render the guilty party liable for damages. Ito daw po yung party fails or refuses to comply. Is either hindi makakomply or ayaw lang mag-comply without legal reason or justification. In most cases of breach of contract, the guilty party will be liable for damages. Magbabayad po ng danyos. Next is Article 1160. Obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17 of this book. So, quasi-contractual obligations naman po tayo. A quasi-contract is that juridical relation resulting from lawful, again, we would like to emphasize lawful, voluntary, and unilateral. Pag sinabi natin unilateral, one party lang yung nag-act, which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of another. We should also take note of this definition that First, it is a juridical relation. It results from lawful, hindi daw po illegal, voluntary, and unilateral acts which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of another. It is not properly a contract at all. Because in a contract, may consent. Pero sa quasi-contract, there is no consent because such consent is supplied by fiction of law. In other words, the law considers the parties as having entered into a contract. Kino-consider daw po ng batas na nag-enter yung parties sa isang contract although they have not actually done so. Bakit? To prevent injustice or the unjust enrichment of a person at the expense of another. For us to better understand this, let us discuss the two types of quasi-contracts, two general types of quasi-contracts. First is negotiorum gestio, which is the voluntary management of the property or affairs of another without the knowledge or consent of the latter. So it is voluntary. Management of the property or affairs of another without the knowledge, di daw alam, or consent of the latter, yung may-ari ng property. Again, we have to take note na siya ay voluntary, siya ay unilateral, kasi yung obligation, papatak lang siya dun sa property owner, and it is lawful. Hindi naman siya ipinagbabawal ng batas. So, as example, Coco went to Sulu without leaving somebody to look after his house in Quezon City. While in Sulu, a big fire broke out near his house. Kaninong bahay daw yon? Kay Cocong bahay. Bahay ni Coco. Through the efforts of Baron is a close neighbor. Coco's house was saved from being burned. Baron, however, incurred medical expenses for injuries sustained. Nagkaroon daw po ng injuries si Baron sa pag-save ng bahay ni Coco. And with that injuries, nagkaroon siya ng medical expenses. So, under the principle of quasi-contract, magkakaroon ngayon si Coco ng obligation to reimburse Baron for medical expenses, although Coco did not actually give his consent to the act of the latter, to the act of Baron in saving his house. Diba walang previous agreement na kapag halimbawa kagaya niyan, nagkaroon ng fire, wala namang previous agreement between Baron and Coco na isa-save ni Baron yung bahay ni Coco. But the law provides, ang law ang nagbibigay ng obligation kay Coco bilang siya ay nag-benefit sa ginawa ni Baron in saving his house. So, ngayon, nagkaroon ng obligation for Coco to reimburse Baron for medical expenses na na-incur naman because of the injuries sustained sa pagsasalba ng bahay ni Coco. So, ayun, yun yung sinasabi nating negotiorum gestio, voluntary management of the property or affairs of another. Voluntary yung ginawa ni Baron nung isinave niya yung property ni Coco without the knowledge or consent of the latter. Without the knowledge or consent of Coco in this case. So, siya ay pasok sa quasi-contract. And then, second is solutio indebiti. Pag sinabi natin solutio indebiti, it is the juridical relation which is created when something is received when there is no right to demand it and it was unduly delivered through mistake. Ito naman daw, solutio indebiti, it is a juridical relation na nag-create kapag merong natanggap, halimbawa, ang isang tao na wala naman siyang karapatang i-demand iyon and it was unduly delivered through mistake. So, the requisites are, first, there is no right to receive the thing delivered, and second, the thing was delivered through mistake. As example, for us to better understand this principle, Bea owes Kim 1,000. May utang daw si Bea kay Kim na 1,000 piso. If Bea paid Gerald, believing that the latter was authorized to receive payment for Kim, the obligation to return on the part of Gerald arises. If Bea paid 2,000 to Kim by mistake, Kim must return the excess of 1,000. So, meron tayo ditong dalawang circumstance ng solutio indebiti. Una, kung si Bea ay nagbayad kay Gerald, na akala ni Bea authorized si Gerald na mag-receive ng payment for Kim, nagkakaroon ngayon ng obligation si Gerald to return such money to Bea. Kasi precisely, si Gerald, wala siyang karapatan to receive the money. And such money was delivered to Gerald through mistake. Dito naman sa second scenario, if Bea paid 2,000 to Kim by mistake, he must return the excess of 1,000. Siyempre, 1,000 lang naman yung utang ni Bea, and Bea paid 2,000. So, we can see na Kim is not indeed entitled to the 1,000 excess. So, she has no right to receive the thing, the money, and the thing or the money was delivered through mistake. Makikita natin yung dalawang essential requisites ay nandiyan sa circumstances na yan. So, yan yung concept ng solutio indebiti. Again, dalawang klase ng quasi-contract, negotiorum justio, and solutio indebiti. We proceed now to Article 1161. It provides that civil obligations arising from criminal offenses shall be governed by the penal laws. Pag sinabi nating penal laws, foremost ay ang ating revised penal code. Itong ating main criminal law in the Philippines. Subject to the provisions of Article 2177 of the Civil Code and of the pertinent provisions of Chapter 2, Preliminary Title on Human Relations, and of Title 18 of this book, Regulating Damages. So, ano po bang ibig sabihin nitong Article 1161? It pertains to civil liability arising from crimes or delicts. Yung fourth source natin, which is crime or delicts. Yung delict, other term lang siya for crime. Pag na-encounter nyo siya, pag na-encounter ay, ang ibig sabihin niya lang ay crime. Oftentimes, the commission of a crime causes not only moral evil but also material damage. So, the general rule every person criminally liable is also civilly liable for damages. Yun ang ating general rule. Yung mga nagko-commit ng crime, hindi lang sila criminally liable. Sila ay civil liable din for damages. Meron lang tayong exception in crimes which cause no material damage. Wala daw material damage. There is no civil liability to be enforced, such as contempt, violation of the Comprehensive Dangerous Drugs Act, violation of the Election Code, possession of firearms and ammunitions. Itong mga exceptions na ito, we can see na kaya siya walang civil liability. Wala siyang obligation. The offender has no obligation to pay a specific amount of money as damages to a specific person, to the offended party, precisely kasi ang offended party sa mga crimes na ito ay ang state. Dito sa mga cases na to, walang private offended party. So, technically, wala talagang mag-a-arise na civil liability dito. However, a person not criminally responsible may still be civilly liable, such as causing damage to another's property without malicious or criminal intent or negligence. So, kahit daw sabihin natin na ma-prove, halimbawa, sa isang criminal case, na a person is not criminally responsible. So, wala daw criminal responsibility yung offender, yung accused, he may still be civilly liable. Kasi, ganito po yan. Itong ating criminal cases, magkaiba ang quantum of evidence required. So, pagdating sa criminal cases, kailangan ma-prove ang guilt beyond reasonable doubt. Yun ang highest quantum of evidence. Pagdating naman sa civil liability, sa civil cases, pagdating sa civil cases, ang quantum of evidence required ay preponderance of evidence lang. So, posible na hindi siya makonvict sa crime, pero meron siyang civil liability. Kasi meron siyang na-cause na damage sa property ng iba, kahit siya ay walang malicious or criminal intent or negligence. So, ano ang scope of civil liability pagdating sa obligations arising from crime? First is restitution. Second, reparation for the damage caused. And third, indemnification for consequential damages. So, para mas maintindihan natin, let us take this example. If akusado is convicted for the crime of carnapping. Carnapping daw yung source ng obligation. Crime of carnapping. The court will order akusado to first return the car or pay its value if it was lost or destroyed. Ito yung tinatawag nating restitution. Pagbabalik ng halaga or the same item dun sa property owner. Next, pay for any damage caused to the car. Yun yung reparation for the damage caused. Babayaran mo raw yung kung anumang na-damage dun sa sasakyan. And third, indemnify such other damages suffered by the offended party as a consequence of the crime, such as moral, nominal, or exemplary damages. Bale, itong mga damages na ito, ang court ang nag-a-award nito at the end of pagdating sa decision. Ang judge ang nagde-decide whether a party is entitled to moral, nominal, or exemplary damages. So, Article 1162, obligations derived from quasi-delicts. Last source, fifth source of obligation shall be governed by the provisions of Chapter 2, Title 17 of this book and by special laws. When we say quasi-delicts, again, the term quasi, take note. A quasi-delict is an act or omission by a person which causes damage to another. So, unang element, causes damage to another. There being fault or negligence. Pangalawang element, there being fault or negligence but without any pre-existing contractual relation between the parties. So, nandito sa baba ang requisites of quasi-delict. Before a person may be held liable for quasi-delict, other term for quasi-delict ay torts. The following requisites must concur. Present daw po dapat lahat itong requisites na ito. First, there must be an act or omission. So, pwede siyang makomit kahit wala kang gawin kasi pwede siya by omission. Such act or omission causes damage to another. May damage to another. Through fault or negligence. Be it fault or negligence, hindi mo sinasadya. Number 4, there must be a direct relation or connection between the act or omission and the resulting damage. Meron daw pong direct relation or connection between the act or omission, yung ginawa mo or hindi mo ginawa, and the resulting damage. And 5th, there is no pre-existing contractual relation between the parties. Gaya po ito kanina ng quasi-contract na walang pre-existing contractual relation between the parties. Example, while having a ball game with friends, Bata broke the window glass of Tanda, his neighbor. The accident would not have happened had they played a little farther from the house of Tanda. In this case, Bata is under obligation to pay the damage caused to Tanda by his act, although there is no pre-existing contractual relation between them because Bata is guilty of negligence. So, isa-isahin natin yung elements. First, there must be an act or omission. So, ang act natin dito is Bata having played ball game with friends. Next, such act or omission causes damage to another. So, ano daw yung damage na na-cause? Bata broke the window glass of Tanda. Yun yung damage. And then, through fault or negligence, hindi naman sinadya ni Bata. It was purely because of his negligence. And there must be a direct relation or connection between the act or omission and the resulting damage. So, clear naman na kaya nagkaroon ng damage, kaya nabasag yung window glass is because tinamaan ng bola. Which is the act or omission, which is the act committed by Bata. And then lastly, there is no pre-existing contractual relation between the parties. Walang pre-existing contractual relation between Bata and Tanda. Hindi sila nag-agree prior sa pagkabasag ng window ni Tanda na Bata will pay kung magkaroon ng damage sa window or any property ni Tanda. And so, this case qualifies as a case of a quasi-delict or torts, and dahil may quasi-delict, may tort, nagkaroon ngayon ng obligation on the part of Bata to pay the damage caused to Tanda by his act committed. So, ayun. I-distinguish natin si crime from quasi-delict or tort. Other term for crime is delict. So, it's practically delict distinguished from quasi-delict. Crime, merong criminal or malicious intent or criminal negligence. Pagdating sa quasi-delict, there is only negligence. Crime, the purpose is punishment. Pagdating naman sa quasi-delict, purpose is indemnification of the offended party. Pag sinabi nating indemnification, mabayaran, masatisfy yung obligation sa offended party. Next is crime, affects public interest. Quasi-delict concerns private interest. Crime is generally both criminal and civil liability, while quasi-delict civil liability only. Kasi nga, quasi-delict wala namang crime dyan. So, siya ay civil liability lang. Pagdating sa crime cannot be compromised or settled by the parties themselves, while quasi-delict can be compromised as any other civil liability. Bakit hindi pwedeng i-compromise or settle ng parties themselves ang crime? Kasi involved ang state pagdating sa crime. The state is also an offended party sa crime, so hindi siya pwedeng i-compromise or i-settle by the parties themselves only. Pagdating sa crime, the guilt of the accused must be proved beyond reasonable doubt. Yan sinasabi natin kanina, beyond reasonable doubt. And sa quasi-delict naman, fault or negligence of the defendant, fault or negligence lang of the defendant need only be proved by preponderance of evidence. Pag sinabi natin preponderance of evidence, mas mababa siya na quantum of evidence sa proof beyond reasonable doubt. And ibig sabihin ng preponderance of evidence, kung ilalagay natin sa weighing scale, sa timbangan, or scales of justice, sabihin na natin, dapat mas angat itong isa. So, kapag sa civil cases, dapat mas matimbang yung evidence siya, yung ebidensya ni complainant kesa sa ebidensya ni respondent. Or more appropriate na term, dapat mas matimbang yung evidence ni plaintiff kesa sa evidence ng kabilang party, which is called the defendant. So, yun yung tinatawag nating preponderance of evidence. So, ayun, that concludes our topic for today. We will again have graded recitation on Saturday.